Welcome to the YouTube channel of Legal Aid Trust. This video is one of the series of educational videos that will be available on this channel under the category General Awareness.
Hello friends, in today's topic we will be talking about remoteness of damage. So in law, the damage must be direct and the natural result or the consequence of the act must be of the defendant, otherwise the plaintiff will not succeed. This is called injure non remota causa sed proxima septor. The English translation of this is basically, in law, the immediate, not remote cause of action of any event that is to be considered. The reason for this is that the defendant is presumed to have intended the natural consequences but not the remote damage. It means that the defendant's act must be the causa causans, or the proximate act or the near cause. There are mainly two tests to find out if the damage is remote or direct. First is the test of reasonable foresight and second is the test of directness. From long ago, the test of reasonable foresight was used, but this theory was rejected in 1921. In 1921, the second theory of directness was applied in the Remoteness and Furnance Limited case. In this, the defendant chartered the plaintiff's vessel to carry a cargo which included petrol. In some cases, the petrol was leaking from the cases and there were vapors of petrol being escaped from the cases. The defendant's servants, while shifting the cargo, negligently knocked off a plank which fell down, and while falling, it rubbed against wood. This led to the wood being ignited and reacted with the petrol vapors and caused an explosion. As a result, the entire vessel caught fire and was destroyed. Hence, the defendant was held liable. It was due to the negligence of the defendant's servants that the fire had broken out, and hence the defendant was liable for the consequences even though they could not be reasonably foreseen or anticipated. This theory was then rejected in 1960 in the Wagon Mount case. There was a return to the reasonable foresight test. The Wagon Mount was an oil raker vessel. It was chartered by the defendant and it had been kept in a harbour in Sydney. It was at a distance of 600 feet from a wharf which was of the plaintiff. In this wharf, there were repairs going on for a different ship. Now, due to the negligence of the defendant's servants, there was an oil spill from the Wagon Mount. Now, this oil spilled and it spread over to near the wharf where the plaintiff was making some welding operations. The plaintiff's manager stopped the welding work and came and asked the defendant if he can continue with the work safely or not, and the defendant assured that there was no danger. The plaintiff's manager himself believed that the oil was non-inflammatory as it was on water and continued with the welding work. 2 days later, a molten metal from the Wagon Mount ship fell on a cotton waste which was mixed with the sea water, and this ignited and caused an explosion, and this caused massive damage to the wharf and equipment. Both the trial court and Supreme Court of Australia applied the rule of directness which was used in the Remoteness case and held that Wagon Mount was liable. But there was an appeal, and this appeal went to the Privy Council in England. The court then reversed the lower court's decisions and held that the defendant, Wagon Mount, will not be held liable. The court said that the test of reasonable foresight should be used, and they rejected the direct rule theory. It overruled the Remoteness case and said that after the event is a fool, but it is not the hindsight of a fool. It is a foresight of a reasonable man which can determine the responsibility. What the reasonable ought to foresee corresponds with the conscience of mankind, and hence the test of reasonable foreseeability must be applied. From this decision, the defendant was not held liable. This has also been approved in recent cases like Hughes versus Lord Advocate in 1963. There is also one more component to remoteness of damage which talks about novus actus intervenius, which is a new act intervening. This states that the act and the consequences are to be directly connected, and the defendant will not be liable for the novus actus intervenus and the consequences thereof. In the case Scott versus Shefford, which is commonly called the squid case, the defendant threw a lighted squib, which is an explosive, into the crowd. It fell on a person X who further threw it on a person, and it fell on a person Y, who further threw it away. Then it fell on the plaintiff and it exploded and blinded one eye of the plaintiff. The defendant was held liable to the plaintiff. Though X and Y had intervened, the defendant's act was the causa consens, which is the proximate act. The defendant pleaded novus actus intervenus, but the court rejected this defense. In another case, which is the Haynes versus the Harwood case, in Haynes versus Harwood, the unattended horse van of the defendant started running as some boys threw stones at the horse. The policeman who attempted to stop the horse was gravely injured. Hence, the defendant was held liable. The contention was that throwing of stones was an intervening act, and hence D was not liable, but this was rejected by the court. Hope you understood more about remoteness of damage. Thank you for watching.
Hope the information contained in this video was useful to you. We look forward to each one of your support and cooperation in making this initiative a success. For more details about the trust, do visit us at www.legalaidtrust.in. Kindly subscribe this channel and click on the bell icon to get the latest updates about various law-related educational videos. Thank you for watching us and have a good day.